Good morning and thanks for being with us here on King 5 in this 9 o'clock hour. I'm Jake Wittenberg. We are following a story very closely that has garnered a lot of attention here in Western Washington. The closing arguments are about to get underway in the trial of a Newcastle man accused of killing a 17-year-old boy outside of a Big 5 sporting goods store in June of 2024, that store in Renton. Prosecutors and defense attorneys are going to make their final case today to jurors in the case of Aaron Myers. He's charged with second-degree murder in that shooting and the death of Hazrat Ali Rohani, a Kent Meridian High School student. He was a junior at the time. Investigators say he was outside of this Big 5 sporting goods store with two other friends when Myers, an on-duty security guard, confronted these boys. Prosecutors argued that the teens repeatedly said that these airsoft BB gun handguns on them were fake. But according to prosecutors, Myers then tackled one of the boys, thinking that there was about to be a robbery of some kind. That is when he shot Rohani 7 times, 6 times in the back. That boy was killed. Family, of course, has been speaking out long during this trial about the loss of this boy. Defense attorneys argue that this realistic handgun was a threat and Myers had no choice but to intervene. So these closing arguments, as you might be familiar with, are the final step in a trial like this. That is when Judge Nicole Hecklinger would send this case to jurors. Let's get to that courtroom in the King County Superior Court right now.
King County Superior Court is now in session.
Please be seated. You can go on the record and then I will say.
Good morning, Your Honor. This is State of Washington versus Aaron Myers, cause number 241-043-671, Kent designation. Elaine Lee on behalf of the state, defendant is present out of custody, represented by counsel.
Good morning, Your Honor. Mark Mitt on behalf of Mr. Myers.
Good morning, everybody. Good morning to our observers. I'm going to start with our media. We have jurors sitting right there, so I'm going to need you to be behind counsel table so you are not disrupting the view of the jurors, of the attorneys, of the exhibits on the screens, and also not a distraction. Thank you. Can I have members of the media here identify yourself by raising your hand? Okay. And you all have read the media order in this case and understand to abide by it? Yes, okay. To everyone else who's present in the courtroom, who's not a party to the case, welcome. I'll remind everybody in the courtroom, party or media or anyone else to have your phones off or silenced. I also am asking you to not have them vibrating because those noises can also be distracting during trial, especially during closing arguments, and be distracting to jurors, the attorneys, and to the bench. Remind everybody, eating in court, the only liquids allowed in court are water. At this point in time, we don't seem to have a concern about overflow of individuals. My thought was if we do end up with the benches full, Mr. Lamore has prepared a sign, so if it needs to be put on the door, that just tells people that the benches are full and puts the Zoom information on the sign. Either party believe that's a problem for purposes of open courts.
No, Your Honor.
No, Your Honor.
Okay. Anything else that the court needs to, and of course, one last thing, I think everybody already knows, but no conversations during proceedings. If for some reason you need to have a conversation, please step into the hallway. And please try to enter and exit quietly. Anything else that I need to address to, okay. Whoever had something going off, please remember to silence that. Anything else I need to address with regards to the case before we bring the jury in?
So, Your Honor, my IT check was unsuccessful. We've been here since 8:30 trying to figure this out. The state has agreed to loan me the court laptop, which we were successful in presenting on. I understand that with the court's instructions and then Ms. Lee's opening, that will then probably take our morning recess prior to my closing. I'm happy to do the sound check then if the court would prefer that. I also would just note I prepared a closing PowerPoint. I'm going to adjust the order of the slides and potentially add a couple new ones in based on Ms. Lee's closing Everything that I've included in there is either screenshots from admitted exhibits or screenshots of the jury instructions. There's no commentary or extraneous information from me. I will show Ms. Lee a copy prior to my closing, and I will mark thumb drive and have it marked for the purposes of court. But I just wanted to let the court know that it's not quite done yet, but I cannot imagine there would be an objection to it. I've reviewed Ms. Lee's PowerPoint and have no objection to hers.
And I do have a copy for the court. I presented one for marking, but if the court would like a copy, I have one to hand forward as well.
I don't need a spare
Okay.
copy, thank you, I appreciate that. As long as there's one marked for the exhibits, identification.
State Exhibit 87 is marked.
Okay. And then we'll at least plan on taking a recess between the state's closing and defense closing, even if it's a second recess, just to make sure that the IT and the PowerPoint issues are sorted out outside the presence of the jury.
Thank you, Your Honor.
Okay. Anything else we need to address before we bring our jurors in?
No, Your Honor.
No, Your Honor.
Okay. Well then, with that, we'll bring our jurors.
Please recognize the jury.
Please be seated. Anything more about the jury instructions to the jurors? Good morning, jurors. Mr. Lamore is going to hand you copies of the jury instructions, which I will be reading to you. You're welcome to follow along if you'd like to. You're not required to, of course. Use the written versions, but I'm going to be reading these to you. After that, you will then hear closing arguments from each of the attorneys in this case. And make sure everybody gets a copy before I proceed. Are you having problems hearing? Okay. Hopefully this is better. Okay. Again, if you do start noticing that you can't hear me, please just raise your hand, cup your ear, and I'll know. Okay. Also, I'm going to be reading these to you from my computer screen, which is easier for me to adjust for the sizing. So if you see me looking at a computer screen, that's just to make it easier for me to read these to you versus holding a paper copy in my hand. Okay. So, jury instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law for my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. A filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during the deliberations consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings or the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations and consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things they testify about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of their testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during this trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by my words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appears to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard that entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction except insofar as it tends to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you may consider the instructions as a whole. You must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. 3. A separate crime is charged in each count. You must decide each count separately. Your verdict on one count should not control your verdict on any other count. 4. The defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. 6. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept their opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the source of their information, as well as considering the factors already given to you for evaluating the testimony of other witnesses. 7. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, they cause the death of such person unless the homicide is justifiable. A person commits a crime of murder in the second degree when they commit or attempt to commit assault in the second degree, and in the course of and in furtherance of such crime, they cause the death of a person other than one of the participants unless the homicide is justifiable. 8. A person commits the crime of assault in the second degree when they assault another with a deadly weapon. 9. A person commits the crime of attempted assault in the second degree when, with intent to commit assault in the second degree, they do any act that is a substantial step towards the commission of that crime. 10. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. 11. An assault is an intentional shooting of another person with unlawful force that is harmful or offensive regardless of whether any physical injury is done to the person. A shooting is offensive if the shooting would offend an ordinary person who is not unduly sensitive. An assault is also an act with unlawful force done with the intent to create another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. A firearm, whether loaded or unloaded, is a deadly weapon. To convict the defendant of the crime of murder in the second degree as charged in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. Intentional murder. A. That on or about June 5th, 2024, the defendant acted with intent to cause the death of Hazrat Ali Rohani. B. That Hazrat Ali Rohani died as a result of defendant's acts. C. That the homicide was not justifiable. And D. That any of these acts occurred in the state of Washington. 2. Felony murder. That on or about June 5th, 2024, the defendant committed or attempted to commit assault in the second degree. B. That the defendant caused the death of Hazrat Ali Rohani in the course of and in furtherance of such crime. C. That Hazrat Ali Rohani was not a participant in the crime of assault in the second degree or attempt to commit the crime of assault in the second degree. D. That the homicide was not justifiable. And E. That any of these acts occurred in the state of Washington. Intentional murder and felony murder are alternative ways of committing murder in the second degree. If you find from the evidence that elements 1A, 1B, 1C, and 1D have been proven beyond a reasonable doubt, or that elements 2A, 2B, 2C, 2D, and 2E have been proven beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which alternative, intentional murder or felony murder, has been proved beyond a reasonable doubt, as long as each juror finds that at least one alternative has been proved beyond a reasonable doubt. On the other hand, if after weighing all the evidence, you have a reasonable doubt as to any one of the elements A1, 1A, 1B, 1C, or 1D, and any one of the elements 2A, 2B, 2C, 2D, or 2E, then it will be your duty to return a verdict of not guilty. 14. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. 15. A participant in a crime is a person who is involved in committing that crime either as a principal or as an accomplice. A victim of crime is not a participant in that crime. 16. It is a defense to a charge of murder in the second degree, as charged in count 1, that the homicide was justifiable as defined in this instruction. Homicide is justifiable when committed in the lawful defense of the slayer, the slayer's child, or any person in the slayer's presence or company, when 1. The slayer reasonably believed that the person slain or others whom the defendant reasonably believed were acting in concert with the person slain intended to commit a felony or to inflict death or great personal injury. The slayer 2. The slayer reasonably believed that there was imminent danger of such harm being accomplished. And 3. The slayer employed such force and means as a reasonably prudent person would use under the same or similar conditions as they reasonably appeared to the slayer, taking into consideration all the facts and circumstances as they appeared to them at the time of the incident. The state has the burden of proving beyond a reasonable doubt that the homicide was not justifiable. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty. 17. As to count 1 only, a person is entitled to act on appearances in defending themselves or another if that person believes in good faith and on reasonable grounds that they or another is in actual danger of great personal injury, or that a felony is being committed, although it afterwards might develop that the person was mistaken as to the extent of the danger. Actual danger is not necessary for a homicide to be justifiable. 18. 18. Great personal injury means an injury that the slayer reasonably believed, in light of all the facts and circumstances known at the time, would produce severe pain and suffering if it were inflicted upon either the slayer or another person. (19) The following crimes are felonies. 1. Robbery. 2. An assault with a deadly weapon. As to count 1, no person may, by any intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense or defense of another, and thereupon kill another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and that defendant's acts and conduct provoked or commenced the fight, then self-defense or defense of another is not available as a defense. Words that do not constitute a threat are not adequate provocation for the defendant to be the aggressor. (21) To convict the defendant of the crime of assault in the second degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. That on or about June 5th, 2024, the defendant assaulted Bilal Amiri with a deadly weapon. 2, that the force used by the defendant was not lawful. And 3, that this act occurred in the state of Washington. If you find from the evidence that each of the elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty as to count 2. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any of these elements, then it will be your duty to return a verdict of not guilty as to count 2. (22) It is a defense to a charge of assault in the second degree, as charged in count 2, that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believed that they were about to be injured, or by someone lawfully aiding a person who they reasonably believed is about to be injured, in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appear to the person, taking into consideration all the facts and circumstances known to the person at the time of the incident. The state has the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty as to the charge. 23. As to count 2 only, a person is entitled to act on appearances in defending another if they believe in good faith and on reasonable grounds that another is in actual danger of injury, although it afterwards might develop that the person was mistaken as to the extent of the danger. Actual danger is not necessary for the use of force to be lawful. (24) Necessary means that under the circumstances as they reasonably appeared to the actor at the time, 1, no reasonably effective alternative to the use of force appeared to exist, and 2, the amount of force used was reasonable to effect the lawful purpose intended. (25) For purposes of a special verdict, the state must prove beyond a reasonable doubt that the defendant was armed with a firearm at the time of the commission of the crime in counts 1 and 2. A person is armed with a firearm if at the time of the commission of the crime the firearm is easily accessible and readily available for offensive or defensive use. The state must prove beyond a reasonable doubt that there was a connection between the firearm and the defendant. The state must also prove beyond a reasonable doubt that there was a connection between the firearm and the crime. A firearm is a weapon or device from which a projectile may be fired by an explosive such as gunpowder. 26. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 12 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, but not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated to you during your deliberations. If after carefully reviewing the evidence and instructions you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted into evidence, these instructions and verdict forms A and B. It should also say special verdict forms A and B as well for recording your verdict. Some exhibits and visual aids may have been used in court but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided to you in each verdict form the word not guilty or the word guilty according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict forms to express your decision. The presiding juror must sign the verdict forms and notify the bailiff. The bailiff will bring you into court to declare your verdict. Instruction 27. You will also be given special verdict forms for the crimes charged in counts 1 and 2. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find the defendant guilty of these crimes, you will then use the special verdict forms and fill in the blank with the answer yes or no according to the decision you reach. In order to answer the special verdict forms yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. I'll ask you now to turn your attention to Ms. Lee, who will give closing argument on behalf of the state.
Thank you, Your Honor. Good morning. 17-year-old Hazra Ali Rohani was killed, and Bilal Amiri's life forever changed because the defendant, Aaron Myers, made decisions based purely on assumptions. He took one look at these boys walking toward Big Five, carrying a BB gun, and immediately labeled them as criminals. Mr. Myers then decided to get out of his truck with his fully loaded Glock 19 pistol in hand and his self-appointed authority to detain these boys. But when these boys did not listen to every single one of Mr. Myers' demands, Mr. Myers got angry. Despite the boys stopping in their tracks, Bilal immediately placing his BB gun on the ground, showing Mr. Myers his hands were empty, raising them up in the air. Mr. Myers wanted Bilal on the ground to submit to his demands. So he decided to force compliance. He grabbed Bilal by the hair, shoved him against the window of Big 5, and pushed him to the ground, all while continuing to point his gun at Bilal's head. He ignored any reasonable actions or words, despite these boys telling him over and over again, it's a BB gun, it's a BB gun. Mr. Myers continued to assume the worst. He shifted his focus to Ali, who was backing away toward Gracie Barra with his hands in the air. And when Ali turned to walk away, Mr. Myers decided to shoot him once, twice, over and over, continuing to shoot as Ali fell to his knees and hands, continuing to shoot as Ali fell face down to the ground. Mr. Myers shot a total of 10 times. An amount so excessive that Mr. Myers couldn't even answer the question in court that we all knew the answer to. Instead, he claimed that he was surprised to find out how many times he had fired. He struck Ali with 7 of those bullets. Once as he was in motion, turning away from Mr. Myers, and the remaining 6 times as he had his back facing Mr. Myers, attempting to walk away. Ali was struck so many times that despite immediate and continuous life-saving efforts, he died at the scene where he fell. It is because of Mr. Myers' poor judgment, solely based on assumptions, that this encounter that never should have happened in the first place turned deadly. Now you, as the fact finders of this case, will determine whether Mr. Myers is guilty of murder in the second degree and assault in the second degree, and whether these crimes were committed while Mr. Myers was armed with a firearm. Members of the jury, you have listened intently over the course of several days of testimony with multiple witnesses and exhibits. And I want to thank you for the time and attention that you have given to this case. I'm sure many of you are wondering, what do I do now that I have all this evidence and I've listened to all this testimony? And Judge Hecklinger has just read to you your jury instructions, which is the law. And it acts as a roadmap for you to understand the law and apply it to the facts of this case. And what I'm going to do is try to break it down for you the best that I can, so that when you go to the jury room to deliberate, you're faced with as little confusion as possible. Because at the end of the day, Mr. Middaugh, Judge Hecklinger, and I, in our respective positions, we're here day in and day out. But I'm sure for most of you, if not all of you, this whole courtroom environment is very new to you. So before I dive into talking about what the charges are, I want to state up front that the burden is my own as the state to not only prove beyond a reasonable doubt that these crimes were committed by Mr. Myers, but also that he was not justified in killing Ali, and that his force used on Bilal was not lawful. So the first charge that I'm going to talk to you about is murder in the second degree, and the law sets out 2 ways that a person can commit murder in the second degree: intentional murder and felony murder. Intentional murder is probably what you all think of when you hear the term murder. Someone intends to kill a person, they then cause the death of the person. With regard to felony murder, if you are committing assault with a deadly weapon or attempting to assault somebody with a deadly weapon, and in furtherance of the assault or attempted assault, you end up taking someone's life, you're still guilty of felony murder, even if your overall intent was not to kill that person. So 2 different ways that you can commit murder in the second degree. I want to break down intentional murder first. And the law states in your jury instruction number 7 that intentional murder is committed when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person or of a third person unless the homicide is justifiable. So with regard to this current case, the state is not alleging that Mr. Myers walked up to these boys that evening with a premeditated intent to kill anyone. If that were the case, he would be charged with a different crime. The elements that the state does have to prove is set out in jury instruction number 13, what I like to refer to as the to convict instruction. That on or about June 5th, 2024, Mr. Myers acted with intent to cause the death of Hazrat Ali Rohani, that Hazrat Ali Rohani died as a result of Mr. Myers' acts, that the homicide was not justifiable, and that any of these acts occurred in the state of Washington. We could take care of a couple of these elements right off the bat. We know that this incident occurred on June 5th of 2024. There is no dispute about that, and most every witness in this case testified to that. We can also take care of the element that requires the state to prove that Hazrat Ali Rohani died as a result of Mr. Myers' acts. Again, this is not disputed. Mr. Myers admitted to firing gunshots at Ali, and there is no dispute that the multiple gunshots that Mr. Myers fired at Ali caused his death. The last element that we can take care of rather quickly is that any of these acts occurred in the state of Washington. This happened at Big 5 in Renton, which is in King County, Washington, so that takes care of that. So that leaves us with Mr. Myers acted with intent to cause the death of Hazrat Ali Rohani, and that the homicide was not justifiable. And I will address whether this was a justifiable killing a little later, but first, I want to talk about Mr. Myers' intent to cause the death of Ali Rohani. Intent is defined for you in jury instruction number 14, and it states that a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. So how do we know that Mr. Myers acted with intent to cause the death of Ali Rohani? Well, he aimed his fully loaded handgun at Ali's direction as he fired 10 gunshots, landing 7 of them in Ali's body. Although the issue of whether it was a justifiable homicide is contested, Mr. Myers' testimony clearly establishes his intent to kill. He testified he was trained to aim for the center mass, that moving appendages are difficult to hit. He testified he was trained not to fire just one shot, that he needs to fire a minimum of 3 gunshots. He aimed for Ali's center mass, striking him multiple times from the middle of Ali's back down to the back of his thighs. You saw from the gunshot wound diagram that Dr. Yared created, where the bullet entry and exit points were center mass, just like Mr. Myers intended. Mr. Myers acted with intent to cause the death of Ali Rohani. So the only issue left to discuss on this charge is whether his killing of Ali was justified. But let's first talk about felony murder. This is another way that someone can commit murder in the second degree. And the law states under jury instruction 7, it states that a person commits felony murder when he commits or attempts to commit assault in the second degree, and in the course of, in furtherance of, such crime, he causes the death of a person other than one of the participants unless the homicide is justifiable. And broken down in your to convict instruction, it's that on June 5th, 2024, Mr. Myers committed or attempted to commit assault in the second degree, that Mr. Myers caused the death of Ali Rohani in the course of and in furtherance of such crime, that Ali Rohani was not a participant in the crime, and that any of these acts occurred in the state of Washington. Before I talk about each of these elements, I want to define some of the terms here that are bolded on the screen. First, let's talk about assault. And there's two different definitions of assault that's set out in jury instruction 11. For purposes of this count, I'm going to focus on this first definition. An assault is an intentional shooting of another person with unlawful force that is harmful or offensive, regardless of whether any physical injury is done to the person. A shooting is offensive if the shooting would offend any ordinary person who is not unduly sensitive. Jury instruction 8 defines assault in the second degree as being committed when a person assaults another with a deadly weapon. Jury instruction 12 tells you a firearm, whether loaded or unloaded, is a deadly weapon. So combining all these definitions together, a person commits assault in the second degree if, with a firearm, they intentionally shoot another with unlawful force that is harmful or offensive, regardless of physical injury. Attempted assault in the second degree in jury instruction 9 is committed when, with intent to commit assault in the second degree, the person does any act that is a substantial step toward the commission of that crime. And a substantial step is defined in jury instruction 10 as conduct that strongly indicates a criminal purpose and that is more than mere preparation. And as part of the elements the state has to prove for felony murder, I have to prove that Ali Rohani was not a participant of the crime. A participant is defined in jury instruction 15 as someone who is involved in committing the crime, either as a principal or as an accomplice. A victim of a crime is not a participant of a crime. So, Mr. Myers, as the person committing the crime, is a participant of the crime. And if Mr. Myers had co-defendants or accomplices who committed the crime with him, they would also be considered participants of the crime. Ali Rohani, the named victim of this crime, is not a participant of this crime. That can easily be taken care of, that element. Now, again, we know that this happened at Big 5 in King County in Washington. That last element is also taken care of. And I'm going to hold off on the issue of whether the homicide was justifiable so I can address both alternatives together. So let's address whether on or about June 5th, 2024, Mr. Myers committed or attempted to commit assault in the second degree, and whether in furtherance of that crime, Mr. Myers caused the death of Ali Rohani. On June 5th of 2024, Mr. Myers intentionally shot at Ali Rohani with his gun, a deadly weapon, with unlawful force, and it was harmful or offensive. It is not required that Mr. Myers intend to actually cause physical injury. It is not required that Mr. Myers intend to kill Ali Rohani with felony murder. What the elements require is that Mr. Myers caused the death of Ali Rohani in course of and in furtherance of the assault with a deadly weapon. So I'm going to repeat that one more time. It is not required that Mr. Myers intend to actually cause physical injury with a shooting. It is not required that Mr. Myers intend to kill Ali Rohani. The very fact that he intentionally shot at Ali with his gun, and the fact that these gunshots were clearly harmful and offensive to Ali, and the fact that this assault resulted in Ali's death is all that is required to satisfy those two elements. So now that we've talked about the two different ways that a person can commit murder in the second degree, I want to highlight a very, very important part of the instruction on page 2, and page 2 of jury instruction 13. Intentional murder and felony murder are alternative ways of committing murder in the second degree. You can find that all the elements under intentional murder have been proven beyond a reasonable doubt, or you can find that all of the elements under felony murder have been proven beyond a reasonable doubt. You, as a jury, do not need to be unanimous as to which alternative, so long as each juror finds at least one alternative has been proven beyond a reasonable doubt. So, I'll give you an example. 9 of you find that Mr. Myers murdered Ali Rohani intentionally, the first alternative. 9 of you. 3 of you decide that Mr. Myers intentionally assaulted Ali Rohani with his gun, and in course of and in furtherance of that assault, he caused the death of Ali Rohani. That would be the second one, felony murder. It doesn't matter how many of you decide on which alternative, so long as each juror finds at least one alternative has been proven beyond a reasonable doubt. Of course, that does not prevent you from finding that both have been committed beyond a reasonable doubt. You do not have to choose one if that is the case. So I want to move on to the real issue of this charge, which is whether this was a justifiable homicide. I need to prove to you beyond a reasonable doubt that Mr. Myers' killing of Ali was not justifiable. You have several jury instructions with regard to this issue, and the first one that I'll address is jury instruction number 16. A homicide is justifiable when committed in the lawful defense of the slayer, the slayer's child, or any person in the slayer's presence or company when 3 things are present. The slayer must reasonably believe that the person slain or others whom the defendant reasonably believed were acting in concert with the person slain, intended to commit a felony or to inflict death or great personal injury. The slayer must reasonably believe that there was imminent danger of such harm being accomplished. And, keyword being and, the slayer employed such force and means as a reasonably prudent person would under the same or similar conditions as they reasonably appeared to the slayer, taking into consideration all the facts and circumstances as they appeared to them at the time of the incident. This is almost like a reverse of what I have been doing thus far in proving to you all the elements beyond a reasonable doubt. Now I have to prove that these 3 things that are required for justifiable homicide are not there beyond a reasonable doubt. Now, the key word in the instruction is and, because all 3 things must be met in order for it to be justifiable homicide. If even one of these things is not met, then it is not justifiable homicide. Because this defense only applies to count 1, the focus is on the portion of the incident when Mr. Myers shot and killed Ali. You will have a different instruction for whether Mr. Myers used lawful force on Bilal. So let's tackle each of these one by one. Did Mr. Myers reasonably believe that Ali, Saddam, and Bilal intended to commit a felony or to inflict death or great personal injury when he killed Ali? The felonies listed under jury instruction 19 are robbery and assault with a deadly weapon. Great personal injury is defined under jury instruction 18, which means an injury that the slayer reasonably believed, in light of all the facts and circumstances known at the time, would produce severe pain and suffering if it were inflicted upon either the slayer or another person. Now, jury instruction 17 states that a person is entitled to act on appearances in defending themselves or another. So if they believe in good faith and on a reasonable grounds that they or another is in actual danger of personal injury, or that a felony is being committed, although it afterwards might develop that the person was mistaken as to the extent of the danger, it notes that actual danger is not necessary for a crime to be justifiable. And this instruction is relevant because clearly Mr. Myers was not in actual danger because Ali had a BB gun, not a real gun. So the question becomes, did Mr. Myers have a good faith and reasonable grounds that he was in actual danger of great personal injury when he shot Ali? Now, up until the point that Mr. Myers shot Ali, several things were known or should have been known to a reasonably prudent person. Bilal had what appeared to be a firearm on his person as he walked by Mr. Myers' truck with Ali and Saddam. The boys stopped immediately when Mr. Myers pointed his gun at them, yelling to stop, drop the gun, and get down on the ground. Bilal cautiously placed his BB gun down on the ground, and this is captured on surveillance video, while keeping his hands exposed and raised in the air. What should be clear, or what should have been clear from the beginning of the contact, was that it was a BB gun. Based on the multiple times they yelled, "It's a BB gun, it's a BB gun." We know they said this because Kayla Rausch, the employee from Big Five, could hear the scared tone of a boy saying, "It's a BB gun, it's not real." And this was through the closed doors of Big Five. We know from the video that Ali stood off to the side and didn't intervene when Mr. Myers shoved Bilal against the glass and forced him to the ground. We know from the video and the testimony of eyewitnesses, including Mr. Myers, that Bilal did not fight back as he got to the ground. We know from the video and the testimony of eyewitnesses that Ali was backing up with his hands raised in the air. The defendant at some point realized that Ali had what appeared to be a gun in the waistband of his pants, likely when his hands were raised in the air lifting his sweatshirt up. We know from the testimony of Saddam Aziz, Salvador Beltran, Deputy Maria Martin, and Deputy Raven Martin that Ali was turning to walk away from Mr. Myers. Salvador Beltran testified that Ali looked frantic and traumatized. Based on the evidence in this case, Mr. Myers did not reasonably believe that Ali intended to commit a felony or to inflict death or great personal injury. Now, Mr. Myers described on his direct testimony that Ali was backing up close to a pillar when he rapidly dropped both hands, lifted his sweatshirt, and grabbed what he thought was a gun. Mr. Myers described a whole exchange of him telling Ali, "Don't do it," and he continued to reach for it, all while Ali apparently did not utter a single word. He also testified that Ali had a small smile on his face as he was reaching for the gun. When I cross-examined Mr. Myers, I pointed out the distance between the pillar that he identified as the one that Ali was backing up to when he reached for his BB gun, and the distance between that and where Ali fell, which is where the Gracie Barra video captures Ali getting shot. Mr. Myers then conveniently testified that Ali raised his hands up a second time, then dropped his hand, wrapping it around the grip of the apparent firearm. So it wasn't until cross-examination that this new detail of Ali raising his hands a second time and dropping them again to grab his apparent gun came out. Members of the jury, you are allowed to use your common sense when interpreting the evidence. In fact, it is laid out for you in Jury Instruction 5 that you can use your common sense and experience to reasonably infer something at issue in the case. It is not reasonable to believe that someone with a BB gun in their waistband would grab it 2 times, wrapping their hand around the grip while a man with a very real gun is pointed in your direction. It is not reasonable to believe that someone being threatened with a real gun would give some kind of sinister smile that Mr. Myers was implying that he gave as he reached for his BB gun. The evidence makes clear that Mr. Myers did not reasonably believe that Ali Rohani intended to commit a felony or to inflict death or great personal injury when he shot him dead. So the next requirement for justifiable homicide is that the slayer reasonably believed that there was imminent danger of such harm being accomplished. Again, I want to go back to the statement that Mr. Myers made about how Ali had his hand wrapped around the grip of the BB gun when he was shot. We watched the video countless times in trial. We've seen just how quickly it happens. An expert had to break it down in thousands of stills just to be able to determine what is happening every millisecond. Members of the jury, I encourage you to watch the video as many times as you need to. Go through the frame by frames as many times as you need to. There is simply no way that Ali dropped his hand down and grabbed his BB gun the way that Mr. Myers described. In the span that it took him to turn before getting shot, less than 3 seconds. You see Ali's hands go from being raised in the air to clutching his abdomen, getting shot. Less than 3 seconds. Broken down for you frame by frame. You see Ali's hands or arms go from being raised in the air to clutching his abdomen as he's getting shot. We know from the testimony of many of the deputies who were on scene to provide initial aid to Ali that they cut open his pants and his BB gun was down by his thigh, clearly having dropped from the impact of getting shot that many times. It was not in Ali's hand. Mr. Myers did not reasonably believe that there was imminent danger of such harm being accomplished. Lastly, the final requirement for a homicide to be justified is that the slayer must employ such force and means as a reasonably prudent person would under the same or similar conditions as they reasonably appeared to them at the time of the incident. Nothing Mr. Myers did throughout this entire incident was reasonable. No reasonably prudent person would approach 3 boys casually going about their day while pointing a gun at them, demanding orders. No reasonably prudent person would then escalate the situation every step of the way by making physical contact, grabbing and pushing, forcing Bilal down to the ground when he wasn't even fighting back. To then senselessly fire so many gunshots that you lose track of how many you even fired, while clearly aiming to kill. That is not force that a reasonably prudent person would use under the same or similar conditions as they reasonably appeared to Mr. Myers that day. I want to reiterate that all 3 of these bullet points must be met in order for Mr. Myers' killing of Ali Rohani to be justified. And they have not been met. But let's just say, for argument's sake, some of you are not convinced that you really think that Ali was reaching for his BB gun. Jury Instruction 20 clarifies what to do in that circumstance. It instructs that no person may, by any intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense or defense of another, and thereupon kill another person. If you find beyond a reasonable doubt that Mr. Myers was the aggressor here, and his acts and conduct provoked or commenced the fight, then he has no claim to self-defense or defense of others. So let's break down what that means. If you believe Mr. Myers committed any intentional act that would cause Ali to have an aggressive or fighting response, which then creates a necessity for Mr. Myers to then act in self-defense or defense of another, which then results in him killing Ali, then Mr. Myers has no claim to self-defense or defense of another. And that's as to murder in the second degree. So let's apply the facts to this case. Mr. Myers initiated the entire interaction by getting out of his truck with the gun pointed at the boys' backs. He then physically grabbed Bilal by the hair. He shoved him against the glass of Big 5. He restrained him against the ground as he continued to point the gun at Bilal's head. He then pointed the gun at Ali, who was trying to back away to leave. That right there is at least 5 intentional acts that Mr. Myers committed that were reasonably likely to provoke a belligerent reaction out of Ali. Which, if he did, by reaching for his BB gun, and Mr. Myers shot at Ali 10 times as a result of Ali's reaching, he does not get to claim self-defense or defense of others. This is not a situation of justifiable homicide. This was murder in the second degree. And now that we have addressed the final issue for your 2-convict instruction for felony murder and intentional murder, you have everything that you need to find Mr. Myers guilty of murder in the second degree. So we're going to go a little backwards in time here, because we're talking about count 2, assault in the second degree, which relates to Bilal Amiri and Mr. Myers' assault against him, which was obviously earlier in time of the incident. We've already talked about what it means to assault someone and how assault in the second degree is committed. And with regard to felony murder, we focused on that first definition. For count 2, I want to focus on the second definition of assault in the second degree, or assault. That a person commits assault in the second degree if they commit an act with their gun with unlawful force done with the intent to create in another apprehension and fear of bodily injury, and does in fact create in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. The 2-convict instruction for count 2, assault in the second degree, requires that I prove on or about June 5th, 2024, Mr. Myers assaulted Bilal Amiri with a deadly weapon, that the force used by Mr. Myers was not lawful, and that this act occurred in the state of Washington. Again, let's take a couple of these issues right off the bat. This charge also occurred at Big 5 in King County, Washington. We know this occurred on June 5th, 2024, just like count 1, because most every witness testified to that. So that leaves us with whether Mr. Myers assaulted Bilal Amiri with a deadly weapon and whether the force used by Mr. Myers was lawful. So let's first address whether Mr. Myers assaulted Bilal Amiri with a deadly weapon. Mr. Myers pointed his gun at the boys, then focused solely on Bilal Amiri for the first portion of this incident. He ordered Bilal to drop his gun, knowing that the power that he held in his hand in pointing the gun, the Glock 19 pistol, at Bilal will create the fear of bodily injury to make Bilal listen. Regardless of whether Mr. Myers actually intended to inflict bodily harm or bodily injury in that moment, he committed assault with a deadly weapon. Bilal Amiri testified he heard, "Drop the gun." He turned around and saw Mr. Myers pointing the gun at him. He dropped the gun. He dropped his BB gun. He put his hands up, and he did what he was told. Mr. Myers physically grabbed Bilal by the back of his hair and his shoulder, shoved him against the window, and pinned him down on the ground, all while still pointing his gun at Bilal's head. You saw this on the video that we watched countless times in court. We went frame by frame, showing every single time that Mr. Myers' gun was visible on surveillance. He continued to point it at Bilal's head until his focus shifted to Ali. Bilal stated during his testimony that he felt it was like a dream, that everything was happening so quick and it was all over the place. They went from being happy and talking to suddenly turning around to see Mr. Myers point the gun at them. Bilal testified that he could see the look in Mr. Myers' eyes, and he knew he did not want to play. And he knew Mr. Myers wasn't playing. He dropped the BB gun immediately onto the ground. He raised his hands up in the air, and he did not fight back, even when Mr. Myers forced him against the window and down to the ground. Mr. Myers did not have to actually intend to inflict the bodily injury, nor did any bodily injury have to result from his actions against Bilal. Mr. Myers assaulted Bilal with a deadly weapon. So that leaves the remaining issue. Was the force used by Mr. Myers lawful? Under jury instruction 22, it states that it is a defense to assault in the second degree as charged in count 2 that a person reasonably believes they are about to be injured, or they lawfully aid a person who they reasonably believe is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all the facts and circumstances known to the person at the time of the incident. Again, jury instruction 23 discusses how Mr. Myers is entitled to act on appearances in defending another. If he believed in good faith and on reasonable grounds that another is in actual danger of injury, although it afterwards might develop that he was mistaken as to the extent of the danger, actual danger is not necessary for the use of force to be lawful. Now, it's clear that the main crux of defense's argument will be that Mr. Myers believed the boys were walking to Big Five to commit a robbery or assault with a deadly weapon, after he saw Bilal with what appeared to be a firearm in hand. The testimony that you heard from Bilal and the video that you watched countless times tells you Bilal was making no threatening gestures with a BB gun. He testified that he was carrying it in his sweatshirt pocket, that his pockets were full, so he took the BB gun out briefly to shift things around and make it fit. He testified they were there to return Ali's BB gun and that he had purchased and exchanged previously at the Kent location. Ali did. He stated Ali was essentially embarrassed to go back to the Kent location and worried about what the employees would think if he tried to exchange or return the BB gun again. Bilal brought his BB gun and had no real intention of purchasing anything, but figured he would get assistance with it or browse for larger BBs because he said that he was having issues with keeping his BB gun. The surveillance stills that you saw in court from the Kent location a couple weeks prior to this incident shows Ali handing the BB gun to the employee and getting a new one. This confirms the boys' reasons for why they were there at Big Five that day. The receipt of purchase and the receipt showing the exchange also shows that what Bilal was saying was true. Mr. Myers testified he had been to the Renton location of Big Five before. He testified he knew the firearms counter was immediately to the right as you walk into the store. You saw with your own eyes from the photograph submitted during Big Five manager Jason Felker's testimony just how close the gun counter was to the entrance. Mr. Felker testified that there is no store policy for how a gun or BB gun should be carried into the store. Both Mr. Felker and Big Five employee Kayla Rausch stated that they had not experienced violent crime at Big Five. Mr. Myers testified to his familiarity with the area, of having witnessed drug deals at the ATM or a fight, but did not say anything specific to Big Five. Ms. Rausch testified that when she saw the boys walk up to the entrance, she saw that they appeared to be having a good time, communicating with each other. She did not find them threatening in any way, despite seeing Bilal with his BB gun and hearing the click-click noises of Bilal clearing his BB gun. Mr. Myers was not acting as security for Big Five that day, nor was he acting as security for the greater shopping complex. He was simply on the lookout for criminal activity, ready to go with his fully loaded Glock handgun, 2 extra fully loaded magazines, a fixed blade knife, and a pocket knife. He testified in court to seeing Bilal rack the slide or doing a press check with what he thought was a gun. But none of that was mentioned in his statement to Officer Edmonds that we saw in court. What he did tell Officer Edmonds was that he saw an individual with a gun in his hand as he walked past Mr. Myers' truck. He tucked it under his shirt and he pulled it out again. You heard in court the inconsistencies in the testimony Mr. Myers provided about what he saw with respect to the BB gun and the statements he made multiple times to the detectives on the night of the incident, never once mentioning that he saw Bilal racking the slide or doing a press check with the gun. Mr. Amiri testified that the BB gun did not even have the capability to slide or rack back. Detective Barfield demonstrated for you in court that the BB gun wouldn't budge when he tried to slide or rack it back. Mr. Myers testified that the boys were not wearing masks. They did not have gloves on. They weren't doing anything to conceal their identities in the way that someone would if they were about to rob the store. And you saw from the surveillance that Mr. Amiri was wearing a gray sweatsuit, which witnesses testified to seeing him wear as well. You saw the photographs admitted during trial that Ali was wearing a Kraken sweatshirt and Gap sweatpants with sandals. It is not reasonable to believe that these boys were going into Big Five that evening to rob it or to commit an assault with a deadly weapon. Given the facts and the circumstances known to Mr. Myers at the time of the incident, he jumped to conclusions, assuming the worst about these boys, immediately approaching them while pointing a gun at them. He never gave them the opportunity to explain or try to hear them the numerous times they tried to say that it was a BB gun. Mr. Myers did not use the force and means a reasonably prudent person would under the same or similar conditions. And the force used was more than necessary. I want to highlight jury instruction 24, which states the definition of necessary. It requires no reasonably effective alternative to the use of force appeared to exist. It also requires that the amount of force used was reasonable to effect the lawful purpose intended. Let's talk about some of the reasonable alternatives Mr. Myers could have exhausted. He could have waited to see what was really going on before making assumptions and initiating the contact that he did. He could have called 911 and left it to the authorities, picked his kid up from Gracie Barra and gone home. He could have stopped after Bilal had his hands up and placed his BB gun on the ground and tried to figure out what was going on before closing the distance the way that he did. Instead, Mr. Myers immediately pointed his gun from across the roadway, walking quickly up to these boys. And when Bilal placed his BB gun down and raised his arms up in the air, Mr. Myers got even more aggressive, continuing to point the gun right at his head while he dragged Bilal every which way. He had Bilal forced to the ground for several moments. The amount of force Mr. Myers used was not reasonable in light of the effective alternatives that he had at the time. The use of force was not lawful here. Mr. Myers is guilty of assault in the second degree. So, we know that Mr. Myers is guilty of both murder in the second degree and assault in the second degree. The remaining questions for you are set out in your special verdict forms. The letter for each special verdict form corresponds with the letter for each verdict form. So for verdict form A, murder in the second degree, if you find Mr. Myers guilty of that crime, you will then answer special verdict form A, which asks whether Mr. Myers was armed with a firearm at the time of commission of murder in the second degree. For verdict form B, assault in the second degree, if you find that Mr. Myers is guilty of that crime, you will then answer special verdict form B, which asks whether Mr. Myers was armed with a firearm at the time of commission of assault in the second degree. You know Mr. Myers was armed with a firearm for each offense because he used his Glock 9 pistol for each offense. You know that it's real because he killed Ali with 7 bullets that were fired from Mr. Myers' gun. But to go even further, you know they were fired from Mr. Myers' gun because forensic scientist Deanna Korrick did a ballistics comparison of the 10 casings found at the scene with the 2 casings that Detective Edwards test fired from Mr. Myers' gun. And she confirmed that all casings were fired from the same gun, from Mr. Myers' gun. Mr. Myers is guilty of murder in the second degree and assault in the second degree. And he was armed with a firearm at the time he committed both. I ask you to return verdicts as such. Thank you.
We'll take our morning recess and then we'll come back and hear from Mr. Middle.
No.
Okay. Mr.
I
Middle.
I just need to make a brief record. There was open weeping for at least 10 to 15 minutes of the state's closing. It was distracting, it was disrupting. It put me in an incredibly difficult position to object to kind of the crying of a family member. It's a breach of decorum, and it has the potential to inflame the passion and the prejudice of the jury. I'm requesting that that individual be excluded from the courtroom for closing.
On the state.
Your Honor, I strongly object to that. I think it's a little hypocritical to be requesting this when Mr. Meyer's side of the family has been quite honestly distracting throughout the entire trial with very loud breathing exercises, and I heard some jangling of jewelry during my closing as well, and I don't know if that was intentional or not, but that was incredibly distracting to my closing. I've heard some crying as well during Mr. Meyer's testimony, so I would object to that. This is the victim's mother.
Thank you. Individuals who are in the courtroom, I understand that this is a very heavy topic we are dealing with here today, and that topic can ignite emotions from individuals who are close to this, close to either party or close to the issues involved here. And this court's main job here is to make sure that the jury only considers the evidence in this trial in the decision they're making and is not impacted by anything outside of that. The jury instructions, of course, give them instructions about that, but I do have to say that if it is difficult for you to be in this courtroom and hear the information being shared today, there is an option for you to observe these proceedings through Zoom. And so I would ask that if this is not, it is not possible for you to sit with this information in the courtroom, to please consider observing these proceedings through Zoom.
Thank you, Your Honor.
Okay, we'll get the jury.
Please recognize the jury.
Please be seated. Mr. Middle,
Thank you, Your Honor.
and the jurors, please turn your attention to Mr. Middle with regards to his closing arguments.
Thank you. Aaron Myers is not a murderer, and he did not commit the crime of assault in the second degree. He didn't want this to happen. He didn't want anyone to get hurt. The reason he got out of his car
is he was trying to prevent violence. Based on what he saw, he needed to act. Because what he saw was this. This is a hyper-realistic imitation firearm designed to look exactly like a Glock 19. Every single officer who came in here and testified told you about how realistic this looks. He saw that in Bilal Amiri's hand. He saw him manipulating it and then concealing it in his pocket, but leaving his hand there with his right elbow cocked out to the side. And then what he saw was this. Another hyper-realistic imitation Glock semi-automatic pistol that was tucked into his waistband. He saw the butt of the gun sticking out. When he saw Mr. Rouhani reaching down for that handgun in his waistband, he followed the training that he'd received. He aimed for the center of mass, and in a split second, he pulled the trigger. Then he stopped, and the second someone identified themselves as police, he followed their commands, he followed their instructions. I told you at the start of this trial that the evidence would show that Mr. Myers is not guilty of both of these charged crimes, and that's exactly what the last 2 weeks of testimony has borne out. Now, I want to start with the legal instructions that you've received and then turn to the facts. And I want to start with the instruction about the burden of proof, instruction number 4. Because all of these instructions are important, but this is your North Star. This is your guiding principle that governs everything else you're going to do when you go back into the jury deliberation room. Because your job isn't just to figure out what probably happened. Your job isn't just to say what mostly seems clear. Your job is to decide what facts the state has proven beyond a reasonable doubt. It has to govern every aspect of what you do. Oh, we have the wrong one up there. That instruction says that the state has to eliminate every doubt for which a reason exists. And the doubt can be based on the evidence presented or the lack of evidence. The prosecution bears the burden of eliminating every doubt for which a reason exists in your mind. This is the highest standard of proof that we apply in our justice system. Civil cases where corporations are suing each other or people are suing each other, where millions or billions of dollars may be at stake, are decided on a standard called the preponderance of the evidence. What is more likely than not to have occurred? The standard directly below proof beyond a reasonable doubt is called clear and convincing evidence. So in order to convict Mr. Myers, you need more than clear evidence, more than convincing evidence. You need proof that eliminates every reasonable doubt from your mind. Here's another way to think about this. When you go back behind that door, you may feel one of 3 ways about the evidence that has been presented in this case. You may feel, on the one hand, that everything the state's witnesses said was true, that the police did a complete, thorough, exhaustive investigation, that those guns were obviously fake, and that Mr. Myers had no reason to be concerned at all when he saw Mr. Amiri with the gun in his hand and Mr. Rouhani with the gun in his waistband. And if that's how you feel, of course, your verdict is guilty. Now, On the other hand, you might feel that Mr. Myers did everything right. That when he saw that gun in Mr. Ramirez's hand, he did the right thing by getting out of the car. And you're certain that getting him on the ground was the right thing to do. And in the moment when he had to shoot, you can say that was absolutely 100% exactly what he needed to do. He never should have been charged with a crime. And if that's how you feel, of course your verdict is not guilty. But there's a third possibility. There's a possibility that when you go back behind that door, you might feel somewhere in the middle. You might feel that Mr. Myers probably did something wrong. You're not sure if every state's witness is telling the truth, but you don't approve of Mr. Myers' actions. You think it's likely that his use of force was not justifiable or lawful. But the state has not eliminated every lingering doubt for which a reason exists in your mind. And if that's how you feel, you might feel torn. You might feel conflicted. And you might feel like you're in a gray area. But what the standard of proof beyond a reasonable doubt means, what that instruction tells you, is if that's how you feel, you're not in a gray area. The law is black and white. You vote not guilty. That's what the instruction says. That's what our Constitution requires of you as jurors. Now, it's extremely important to point out that the burden of proof applies to your instructions regarding self-defense and defense of others. The state bears the burden of proving that the homicide was not justifiable beyond a reasonable doubt. This is instruction number 13, and those are snippets from Part 1C and 2D, the elements of the offense. This also applies to assault in the second degree. This is instruction number 21, and it states that the state has to prove beyond a reasonable doubt that the force used by the defendant was not lawful. Mr. Myers has no burden to prove that he acted in self-defense or in defense of others. And this is critical because this is the only element that's at issue in this case. All that other stuff, state of Washington, the identity of Mr. Myers causing death, none of that is at issue. Whether this was justifiable and lawful, that will be your task as jurors. There are specific instructions about when the use of force is lawful as a defense to assault in the second degree, and when homicide is justifiable as a defense to murder in the second degree. This instruction, number 22, is about assault in the second degree. It allows an individual to intervene on behalf of other people, to aid someone that they believe is about to be injured. It does not require that the person fear death. It does not require that the person fear a serious bodily injury. And it doesn't use that word imminent. It says about to. That's a distinction. For murder in the second degree, homicide is justifiable when three things are present. The slayer reasonably believed that there was going to be a felony or to inflict death or great personal injury. And any assault committed with a deadly weapon is a felony. So the question isn't whether these individuals were about to commit an assault with a deadly weapon. The question is whether Mr. Myers reasonably believed that they were about to do so. The second element does require imminence, that there's imminent danger of a harm being accomplished. And then the third is that he employed such force and means as a reasonably prudent person would use under the same or similar conditions as they reasonably appeared to the slayer. The slayer in this instruction is Mr. Myers. So you have to put yourself in this position that Mr. Myers was in on the date of the incident and say, what are the facts and circumstances as they appeared to him at the time of the incident? And that word appeared, how it appeared to him, is so important that we actually have two separate instructions talking about appearances and how things appeared to Mr. Myers. As to count one, a person is entitled to act on appearances in defending themselves or another if they believe in good faith and on reasonable grounds that another is in actual danger of great personal injury. It says that a person might be mistaken about the extent of the danger, and that's okay. And then the last line, actual danger is not necessary for a homicide to be justifiable. The people who wrote these instructions were thinking about situations exactly like this. It's so important that we have a separate instruction for count 2. A person is entitled to act on appearances if they believe in good faith and on reasonable grounds that another is in actual danger of injury. Again, it might be the case that the person is mistaken. And for the criminal context, what you're here to decide, that's okay. Actual danger is not necessary for the use of force to be lawful. The law does not require you to convict people, to punish people who ended up being mistaken, as long as they were acting in good faith in the moment. Now, I'll come back to a little bit of the law, but I want to talk about the facts of the case. And I want to start with the last part of the case, what happened on Monday. The defense case involving Mr. Myers and Mr. Baker. Now, as you know, the defense has no obligation to put on a case to call any witnesses. But it was the defense, it was me who retained a video expert. It was the defense that got the frame-by-frame video that are present there in Exhibit 5 and Exhibit 83 for you to look at. It was the defense that was not satisfied with this zoomed-out video that you'll be trying to hit play and pause on endlessly on the VLC media player on your jury laptop back there. It was the defense that wanted you to have the most accurate zoomed-in image possible so you could see what was actually happening. That's really significant. Why was the state satisfied with this video? Is it because on the video it's so hard to squint and see that Mr. Amiri actually was pulling his gun out? Is it because it's so hard to see at the very edge of the frame that Mr. Rohani actually was dropping his right arm down to his side before the shots were fired? In any event, you now have this evidence because I produced it for you, and I urge you to rely on it back there as many times as you need to get the clearest possible view of what happened. And of course, you know Mr. Myers had an absolute right not to produce any evidence and not to testify. But he got up on that stand and told you what he saw. He subjected himself to the skillful cross-examination of an experienced prosecuting attorney because it was so important for you to know what was going through his head in those critical moments. Now, here's what he told you. He told you he saw a gun in Bilal Amiri's hand. And you know he's telling the truth because that's what the video shows. In the early frames of that video, you can see him in his gray sweatsuit walking in front of Mr. Myers' truck with the gun in his hand. He says he saw Mr. Amiri put his left hand on the gun, and he thought he saw him racking the slide or doing a press check. Again, the video shows Mr. Amiri doing some kind of manipulation and movement with that gun. Mr. Myers told you that he never heard anything about BB gun, and the men were saying, "What the fuck," and "fuck you," and acting indignant. Now, Mr. Amiri claims that he was screaming the words BB gun over and over at the top of his lungs. But the state has called all of these witnesses who are in cars just feet away. And almost all of them could only testify to what Mr. Myers was saying, not what Mr. Amiri was saying. The only witness who claims to have heard anything about a BB gun is Kayla Rausch. And there are significant reasons that I'm going to discuss in a little bit to believe that her testimony is not true and has been influenced by what she saw on the news after she gave her statement to the police. Next, Mr. Myers told you that he saw the butt of a gun in Mr. Rohani's pants. He told you it was tucked into his waistband. And again, we know that's true because the deputies who responded cut away Mr. Rohani's pants and found it on the inside of his right thigh, muzzle pointed down. Not in a pocket, in his waistband. Mr. Myers told you that Mr. Rohani started to drop his right hand down to his side, to his waistband, before the shots were fired. Again, we know that's true. You can see it on the video, on the frame by frame. The right elbow is down before any shots are fired. And we also know that's true because of Dr. Yared's testimony. Dr. Yared, working for the King County Medical Examiner's Office, she's a government employee, her office is at Harborview, she's done thousands of autopsies. She watched the video, she did the bullet trajectory analysis, and she told you that based on her analysis, her expert opinion is that the first bullet entered the outside of Mr. Rohani's right arm, left through the inside of his right arm, then penetrated through the right side of his chest. Little detail, I'm not sure if you caught it, she also said that that arm must have been pressed against the chest or just an inch or so away. Not up here, not down here, all the way down before shots were fired. That could not happen if his hands were up in the air. Mr. Myers testified that he feared for his life, that he thought he was going to die. So he fired. And he thought he fired 2 or 3 times. He told you it was over in a split second. He told you that he couldn't even hear the shots. And again, we know that must be true. Why else would he fire in that moment? This is someone who was a first responder for 20 years. He was in the military. He deployed to combat zones. Never even fired his weapon at a person in his entire life. And now, in this moment, 52 years old, picking up his son from a jiu-jitsu class, he decides this is the moment that he just wants to shoot. That does not make any sense. He shot because he feared for his life. That's what he told you. His testimony alone is a reason to doubt the truth of the charges. When Mr. Myers got out of that car, his actions were lawful. It was lawful force because he believed that Mr. Amiri was armed with a gun and was about to injure someone, about to commit an act of violence, either a robbery or a shooting. That is lawful force. He didn't shoot Mr. Amiri. He didn't hurt Mr. Amiri. He yelled at him, and then he forced him to the ground. That is exactly the type of force, not causing injury, that a reasonably prudent person would use to stop a potential robbery or a shooting. When Mr. Myers fired his weapon at Mr. Rohani, that was justified because he believed that Mr. Rohani was pulling a gun on him. In that moment, he believed he was about to die on the sidewalk just feet from where his son was taking jiu-jitsu class. That is a reasonable fear of suffering death or great personal injury. That is a reasonable fear of imminent injury. And he used the only force available to him for force that was about to be applied with an apparent gun, his own gun. That, right there, is why you should find Mr. Myers not guilty of both crimes. Now, I understand that Ms. Lee has argued that you shouldn't believe Mr. Myers because there were some minor inconsistencies between his testimony on Monday and his statements on the night of the incident. But I want to be really clear about context. Just a couple of minutes after this incident, he told Officer Edmonds exactly what happened. Now, Ms. Lee said, well, it wasn't until trial testimony that he added this convenient detail that Mr. Rohani put his hand on the gun twice. Listen very closely to this video.
I saw two armed individuals attempting to enter that store.
Two armed individuals going into Big Five. Guns.
One had one in his hand, and as he walked past my truck, and then he tucked it in under his shirt, and then he pulled it out again as I was approaching from behind. I told him to drop it. He dropped it. The other individual I saw the butt of a handgun in his pants. He attempted to pull it. I told him to put his hands up, and he attempted to pull it.
Alright. So you told the one guy to drop it. He dropped it. You told the other guy to drop it.
And he tried to hit. I told him to put his hands up.
Don't put his hands up. And he tried to pull.
He said right there, he reached for it. I told him to put his hands up. He reached for it, and I shot. That's not a convenient detail that was added on Monday. That's exactly what he told Officer Edmonds just minutes after this occurred. There's no inconsistency there. Now, later on that evening, he sat down for an interview with two detectives at the Renton Police Station. You saw for yourself what that interview was like. Now, this is not an admitted exhibit. It's not going to go back to the jury room. So I just want to show it to you one more time so you can assess what this must have been like for someone who said it was like being in a bad dream.
Like my partner said, we just want to hear your side of the story, what happened then.
Okay. There is a garbage can right there. We can roll.
Yeah, closer to you, sir?
Yeah, we can roll.
Yeah.
Right there, Mr. Myers.
Just lean right over.
Lean right over, sir. We've got clean water for him.
Yeah. Take as much time.
We can see that you're upset, okay? And there's no rush tonight.
That's my breath's working, okay? I know that's really hard right now. It's just some good breathing. Try to bring your heart rate down a little bit for me. Okay? Right on there. It's totally understandable to be upset. But it's important when we get the chance to hear your side of the story. We need to talk. Get your heart rate down. Whenever you're ready, whenever you're ready.
He was sobbing. He was about to throw up in a trash can. I mean, they were trying to get him to do breathing exercises. Not only had this been incredibly stressful, you have to remember he was at work at 6:30 that morning, worked a 12-hour day. He told you he did his best to tell the truth, and under the circumstances, the few minor points that the prosecutor was able to make about what was slightly different between his testimony and what he said that night, out of that enormous transcript that she plopped down in front of him, does not mean that he was trying to lie then, or that he's doing anything less than telling you the truth to the best of his ability in this trial. And when you're assessing inconsistencies, remember this. This event happened nearly 2 years ago, and no one has a perfect memory of what occurred. I want to give you some examples that I picked up on during the trial. Maybe you saw more or different ones. There's Maria Martin, the first witness. She had no memory of a minivan in front of her, even though that was clear on the video. She thought the young men passed in front of her, like 3 or 4 feet in front of her car. When we watched the video, her car's never even visible in that video. The young men walked in front of the minivan, not her car. Deputy Ladd Maralt, he was adamant that he was right behind a marked police car with lights and sirens, directly in front of him. But every other witness who testified said that wasn't the case. There was no marked police car there. Detective Pelzar said, yeah, I had a perfectly normal black Ford Explorer. No one could have told or seen that that was a police vehicle. Deputy Lemus, he initially thought that Mr. Myers walked in front of his car. He said that in an interview, but then he said, oh, now I realize that Mr. Myers, I was actually watching him in my rearview mirror. Wei-Han Wang, he had no memory of the Toyota Highlander in front of him, and he claims that he only started backing up after the shots were fired. But remember, he was in a gray Honda Fit, and you can see just at the edge of the video, we watched it with him, a gray car pulls up behind the Highlander and then starts reversing before the shots were fired. Salvador Beltran, first of all, he was 75 feet away in the process of pulling a U-turn when this was happening. And on the stand, he couldn't even remember seeing Mr. Amiri on the ground until he had his memory refreshed with a transcript and said, oh yeah, now I remember, there was a second young man there. Does that mean that all 5 of these witnesses are liars, that they're biased, that they're trying to get some type of upper hand in this trial? Of course not. But as you think about the testimony in this case and as you assess the credibility of all of the witnesses, remember that it's just not fair for anybody to expect everyone to make multiple statements that line up perfectly. Not any of the state's witnesses, and certainly not Mr. Myers. I want to be really clear as well about how the burden of proof applies to Mr. Myers' testimony. His testimony does not have to prove his innocence beyond a reasonable doubt. He does not have to provide clear and convincing evidence that he's innocent. He does not even have to prove that it's more likely than not that he is not guilty. Your job as jurors isn't just to decide who you believe more, whose testimony is more reasonable. If Mr. Myers' testimony creates any doubt for which a reason exists in your mind, you vote not guilty. Now, I talked about inconsistencies, but some of the testimony that you heard in this trial goes beyond having a bad memory or making minor mistakes. And I want to talk about 4 witnesses: Maria Martin, Kayla Rausch, Saddam Aziz, and Bilal Amiri. First, I want to talk about Deputy Martin. She's the star witness, the first person called to the stand. She claimed to have a clear view of this whole thing. But her testimony was off. It was biased. It was not the type of neutral reporting of facts that you would expect from a trained police officer who's not supposed to have a dog in the fight. First, she was adamant. She said over and over again that the young men were complying. She used that word again and again, complying. But then she admitted that she couldn't hear anything that Mr. Myers was telling the young men to do. So that word, complying, doesn't make any sense. He was telling them to get on the ground, and they weren't complying. That's not disputed at all in this trial. Second, Deputy Martin was absolutely clear about what she saw. Mr. Rouhani had already turned around, had his hands up, and was walking away from Mr. Myers when the shots were fired into his back. Now, I understand why, if there wasn't a video, if there wasn't Dr. Yared's testimony, the state would want her to be the first witness. That is dramatic testimony. It makes Mr. Myers look like a killer in cold blood. It's going to color your view of the entire trial. But it just isn't true. Mr. Rouhani hadn't turned around before he was shot. He wasn't running away. He didn't have both hands up in the air. We know that from the video, and we know that from Dr. Yared's testimony about the bullet trajectory. This went beyond minor mistakes, and when you're considering whether the state has met that awesome burden of proof beyond a reasonable doubt, I don't think Maria Martin's testimony adds to that. I think it actually detracts from it, that they're putting so much weight on what she had to tell you. The second witness I want to talk about is Kayla Rausch. Ms. Rausch testified not only about what she saw, but also about what she heard. And she testified that she heard 2 really significant things. First, she testified that she heard this telltale click or soft tink of a BB gun being cleared, meaning that someone had pulled the trigger or manipulated the gun to get the BBs out. Second, she testified that she heard one of the young men say, "It's a BB gun, it's not real." One time, not yelling, in a slightly elevated voice. This testimony is not credible. First and foremost, Bilal Amiri himself denied that he ever pulled the trigger or did anything to that BB gun that would have caused it to make a click or a soft tink. I specifically asked him if he pulled the trigger. He said no. He denied ever putting his left hand on the gun as well. Ms. Rausch also testified that she heard this when she was in the store by the gun counter, walking from the gun counter to the cash register. The doors were closed when the incident was occurring, and there are actually people in the store shopping. Just next to her, Jason Felker was having a conversation with a customer at the gun counter. There's no way that she heard a soft tink or a click coming from the middle of the parking lot. She also testified that she heard the phrase BB gun or "it's not real," but her story doesn't add up. Mr. Amiri said that he was screaming it over and over and over again at the top of his lungs until his throat hurt. She said, well, I heard him say it one time in a slightly elevated voice. That's not consistent. And then you heard about what Ms. Rausch told the police, and this is so important. She first talked with an officer, and then she was given the opportunity to write a statement in her own words under penalty of perjury about what she saw. And we went through that over and over again. 3 times she told the police the young men were carrying guns. Not BB guns, not airsoft guns, not replica guns. Guns. If she knew in that moment that there had been clicking and a soft tink and the young men had been saying BB guns, she absolutely would have told the police that. But instead, she admitted that the first time she told anybody about that was when she was talking with me in October of 2025. 16 months after this incident occurred. And what happened during that time period? I mean, this is a really big deal for the people who were there that night. There were shots fired. You saw dozens of police officers respond. She went and she watched the news. She went online, she went on YouTube, and she watched news stories about what happened. Of course she heard about the BB guns. Of course she heard about what the young men were reported to have said. And now her statement about what she saw and heard has changed. It's fundamentally different than what she told the police. I don't know if she's biased, pathetic, or her memory is playing tricks on her, but her testimony about what was said is not the type of credible, reliable evidence that satisfies the state's burden of proof beyond a reasonable doubt. Next, I want to turn to Mr. Aziz. It's clear that Mr. Aziz is extremely angry and upset with Mr. Myers. But his testimony was so colored by that anger that it led to him saying a ton of things that were just obvious falsehoods. He said he'd only hung out with Bilal Amiri once and that he'd only ever seen him 3 or 4 times. That is obviously not true. Bilal told you that he saw Mr. Rohani multiple times a week and that Mr. Aziz was always there. These young men were not strangers, and it's extremely odd that Mr. Aziz tried to mislead you about that. Mr. Aziz testified that he had no idea why they went to the Big Five in Renton. He admitted they were right next to the Big Five in Kent. He acknowledged that the Renton Big Five was way out of their way. But he says he has no idea why they went up there, and he had no memory of this conversation that Mr. Amiri reported about being in the back of the car heading to Covington when a police officer came up and they had to turn left. Mr. Aziz testified that he put his hands up when Mr. Myers was there. I showed him the video, and he admitted he never put his hands up. Ms. Lee pointed out, well, he was out of the video frame for a few seconds. But here's something that I hope you picked up on. We don't just have the video image of the people, we also have the shadows. So in this video frame, Mr. Aziz is right here behind this light, and his shadow comes here through into the Gracie Barra. And we can see his hands right here. In that moment, his hands aren't up. He's taking a picture with his cell phone. When you watch the frame by frame, you'll see from his shadow that he reaches into his pocket and he pulls out the cell phone to take a picture. His hands are never up. Mr. Aziz claims that he was yelling the whole time that it's a BB gun, it's a BB gun. But then he admitted that, well, when he talked to the police, he said he wasn't saying anything because he doesn't speak English well enough. The next thing is Mr. Aziz claims that he saw Mr. Rouhani put his gun on the ground before the shots were fired. Again, this is obviously false. Mr. Amiri never said anything like that, and the police found the gun tucked inside Mr. Rouhani's waistband, not on the ground, several feet away. Mr. Aziz said Mr. Rouhani had the receipt for the gun on him. This would have been incredibly important evidence. No one found that. It wasn't recovered at the scene. The only receipt that was produced was from a Big Five custodian of records from the month before. Next, Mr. Aziz claims that he could see, definitely see, that Mr. Rouhani had his hands in the air and never put them down. But this was his vantage point. You can match this photo to him holding up the cell phone in the shadow and see he could not possibly have seen that from where he was located. Final thing, Mr. Aziz claims that a police officer got out of his car and told Mr. Myers to drop his gun before the shots were fired. If that were true, that police officer would have come in and testified to you. There is no way that is accurate. Now, Bilal Amiri's testimony was also really difficult to take at face value. His story about why they ended up at the Big Five in Renton was just completely far-fetched. According to him, he wanted to go to the Big Five in Kent. And I showed you this demonstrative exhibit where these are the home and the Big Five in Kent, right next to each other. He said, oh, well, it was my car, I didn't have money for gas, I didn't want to drive, but Mr. Rouhani was really adamant that he wanted to go to a different Big Five. So we started driving to Covington, which is 7-8 miles away. And then, while we were driving to Covington, a police officer started following us, and we didn't want to have a police interaction, so we hooked a left to get away from the police and ended up, again, 7-8 miles away in Renton. That does not make any sense. Then he said that when they got there, well, he brought his gun for no reason at all, also because it wasn't holding BBs, also to get a new attachment like a laser sight, and then also because he was going to get larger BBs even though he acknowledged he had the correct size BBs in the car. Again, that does not make any sense. Next, Mr. Amiri told you that he was screaming that it was a BB gun over and over again at the top of his lungs. But no one backs this up. Even Kayla Rausch, who claimed to have heard this screaming or something about a BB gun, didn't describe it as screaming and said it only happened once. And finally, Mr. Amiri repeated that untruth that Mr. Aziz shared with you about the police arriving before the shots were fired and ordering Mr. Myers to put down his weapon. It's not on the video. You can say with certainty that that's just not true. I don't know what to make of the decision of Mr. Aziz and Mr. Amiri to come in here and tell you all of these things. Some of these extraneous details that aren't necessary for their testimony, that obviously aren't true. But I think it's a real possibility that their lies about the minor details in this case point to the, again, possibility that they were lying about what they were going to do that day. I mean, imagine that these young men were on trial for attempted robbery, taking a substantial step towards robbing the Big Five. They had apparent firearms, one tucked into a pocket, one tucked into a waistband. If they were on trial and got up on the stand and offered that testimony about what they were doing that day, they would be getting skewered by the prosecution. You were trying to return your guns with no receipt? You drove an extra 7 miles away from your house just to do a return? You didn't put your guns in a bag or a box? The last time you took the gun in, you put it in a backpack. We saw that. We have video of you knowing how to safely return a gun. You were carrying a gun, one gun tucked into your pocket and the other into your waistband just to return them? That testimony would sound utterly ridiculous. So I don't know what they were doing that day. I don't know why they were going to that Big Five. But the bottom line is, it doesn't matter. Okay? The law that the judge has given you is that it is crystal clear. Mr. Myers was entitled to use force based on the appearance of a threat. His use of force is still lawful, no matter what you think Mr. Rouhani, Mr. Amiri, and Mr. Aziz were actually doing on the night of June 5th, 2024. Now, yesterday and then again today, I just want to point out, I think there was a little bit of confusion about this pillar, okay? So, this is a still frame from the video, and I want to point out on this still frame that you can see the shadow from the pillar that is directly between the Gracie Barra and the Big Five. That pillar is directly behind this potted plant and this stanchion that goes up and is holding the glass on the inside of the Gracie Barra studio. And we know that it's the shadow of that pillar because we can see the shadows that are from the outside there, and you can see which direction they're heading. So when Mr. Rouhani is over here on the right side of the video, and he puts his right arm down, okay, he's on the far side of the pillar towards the Big Five, not on the near side of the pillar towards the Gracie Barra. And where he ended up, where that yellow tarp ended up, is not relevant because there was testimony that first responders moved his body as they were applying first aid. Now, I want to turn back a little bit to talk about the police investigation in this case. The police did most of the basics that we would expect of them. They photographed the scene, they obtained surveillance video, they secured the evidence that they found out in front of the Big Five. But I want to point out that there were 4 really significant misses in this case. And when you're considering whether the state has proven its case beyond a reasonable doubt, I want to remind you that the burden of proof is on the state, and that proof beyond a reasonable doubt requires you to consider both the evidence and the lack of evidence. First, there's this guy in black, right here. You'll see in the video, if you go frame by frame, he is maybe 15, 20 feet away, looking through a clear glass door. We didn't hear from him, nothing about who he was. He was wandering around in front of the Gracie Barra studio that whole time. Next, there's this Toyota Highlander. It's very clear that the person who was the driver of this Toyota Highlander was in a great position to see exactly what was happening. Same position, same vantage point, maybe even better than the guy in black. I asked Detective Barfield about that, and he said, well, I'd love to have talked to him, but I didn't have his license plate. Well, his license plate is CHT2030. It's clearly evident in Officer Edmonds' body cam that's been admitted here. That's just a miss. Next, there's the guy at the ATM. Deputy Ladmeralt told you there was someone right there, and Detective Barfield said, oh yeah, we talked to him. That was Salvador Beltran. But Salvador Beltran told you that wasn't true. I was in my car. I never got to the ATM. So again, another person who was closer, but a better viewpoint, better listening point, who wasn't interviewed or called by the state. And finally, there's this issue about the operability of the BB guns. Okay, a big part of the state's case is that these young men were taking the BB guns back to Big Five because they weren't working. Now, we have a crime lab that can go through and can test all 10 shell casings that Mr. Myers fired when it is not even remotely in dispute that those were fired from his gun. No one else fired a shot. That's not a question in this trial. But for the BB guns, nothing. There's a famous slogan, trust but verify. The state here just skipped the second part of that. They said, we don't test fire BB guns, so we have no evidence about whether they're working or not. So if any of those four things are a question for you, if that's a doubt you have, your job as a juror is to hold that against the state, not Mr. Myers, because they have the burden of proof. Now, before I conclude, I want to address three issues that the state has raised. First, there's this issue about the aggressor. Okay. Here's the instruction. Ms. Lee went over the whole thing. I want to highlight a few things that are really important about this. First, this instruction only applies to count 1. So when you're considering whether or not this instruction applies, you're only considering it with respect to the interaction between Mr. Myers and Mr. Rouhani, not Mr. Amiri. That's count 2. The second thing is, this instruction requires Mr. Myers to have committed an intentional act reasonably likely to provoke a belligerent response. And look, the way that the instruction contemplates this, the situation that this is trying to address, is related to a fight. It says the conduct provoked or commenced the fight. That is not at all what Mr. Myers was trying to do. He wasn't challenging these men to a fight. This wasn't some macho thing where he was trying to goad the men to pull their guns on him because he was itching to shoot. He was doing exactly the same thing that the police officers did just a few seconds after shots were fired. He pulled his gun, he pointed his gun, exactly like Deputy Lemus, exactly like Detective Pelzar. He ordered them to put their guns on the ground, exactly like Detective Lemus did to him, exactly like Detective Pelzar did from a different angle. He ordered them to put their hands in the air. Again, you see it on the video, you heard their testimony. That is exactly what law enforcement was trying to do to secure the scene, to make everybody safe. And then he ordered them to get on the ground. To the letter, exactly what the police officers were telling him to do in that moment. No one's up here arguing that Deputy Lemus was the aggressor, or that Detective Pelzar was an aggressor, or that they were trying to provoke a belligerent response. They were trying to secure the scene. The state has to prove that Mr. Myers was this aggressor, that he was intentionally acting to provoke a belligerent response beyond a reasonable doubt. So if you have any doubt at all as to whether Mr. Myers was trying to start a fight, if you think it's possible he was genuinely trying to secure the scene and make it safer after seeing a gun, you ignore this instruction completely and you imply the other self-defense rules as outlined in the other instructions. Now, the next thing I want to talk about comes from this necessary instruction. This applies to count 2, the assault charge, and it says the force used cannot be more than is necessary. And the instructions defined necessary as no reasonably effective alternative to the use of force appeared to exist. And the states argued, well, Mr. Myers should have just stayed in his car and let other people take over. You know, that's an argument you can make from a desk. That's an argument you can make in hindsight. Mr. Myers doesn't have a law degree. He didn't graduate from college. But what he did do was work as a first responder for 20 years. He joined the military, he deployed to combat zones, and he's responded to the scenes of robberies and shootings and seen people die from being shot in the head. He told you about seeing a cashier who was shot at a carryout restaurant because they were in the wrong place at the wrong time. He told you exactly what he was thinking. My son is in Gracie Barra. He's coming out any minute. When you wait, people die. And Mr. Myers also just wasn't any guy off the street intervening. He works in the security industry. He has a private armed security guard license. You heard what he did. Exactly the same thing the police did. Pointed the gun, drop your weapon, hands in the air, get down on the ground. He also told you he wanted the police to arrive. So he was yelling at the top of his lungs that he wanted, hoping that a bystander would call 911. And that's exactly what happened. Remember Kayla Rausch's testimony. She told you that she started walking over to call 911 when she heard the yelling before the shots were fired. Based on the threat Mr. Myers saw in that moment, waiting to see what would happen, sitting in his car, hoping that the police responded in time, was not a reasonable option. Finally, I want to talk about this idea that because Mr. Myers fired 10 times, that the force was excessive. I get that this is a somewhat appealing argument, but when you look at it at its core, it does not make any sense. And it doesn't make any sense for two reasons. First, Mr. Myers told you that he thought he only fired for a split second. He told you that he only thought he fired 2 to 3 shots. He told you that he never even heard the gunshots. And everyone who came in testified that the shots were in quick succession and they only heard 3, 4, 5. Nobody said, oh yeah, I heard 10 shots. That just wasn't testimony that you heard. Mr. Myers told you about his training, and he told you that he was reacting to a threat he saw. He told you that even though he was in the military for 8 years and deployed overseas, he'd never fired his gun at a person before. The number of shots fired is not some conscious decision, it's a reaction to what he saw in front of him. There's no credible evidence that he continued to intentionally fire his gun after he no longer perceived a threat. Dr. Yared's testimony is actually very consistent with this. She told you that she watched the video and looked at the bullet trajectories, and she told you every single one of those bullet trajectories was consistent with the bullet having been fired, with the shot having been fired, before Mr. Rohani even reached the ground. She told you that she couldn't tell whether any of those shots were fired while he was on the ground or whether he was turning, falling, and on his hands and knees. Watch the frame by frame. There are no muzzle flashes, there's no audio, but you can see each one of those frames is just milliseconds. Just milliseconds. So it is very consistent with what Mr. Myers said, that this happened in the blink of an eye. But even more importantly, this argument doesn't make any sense because Dr. Yared told you that the first shot was absolutely 100% the fatal shot. She told you that it went through the right side of the arm, the left side of the arm, into the chest, across the body, puncturing the liver and a major blood vessel. It doesn't matter how many times Mr. Myers shot after that, whether it was 0, or 10, or 100 times, it would not have changed any aspect of the case. Because that first shot was the fatal force that was applied, it doesn't matter what happened next. What you need to evaluate is whether that force that Mr. Myers applied, that fatal shot, was justified. And of course, Mr. Myers was absolutely entitled to shoot someone reaching for a hyper-realistic handgun tucked into his waistband. Now, the state bears the burden of proof, so they get to have a rebuttal closing argument. and I won't get another opportunity to address you. So what I would ask of you is this. As Ms. Lee is giving her rebuttal, I want you to ask, what would Mr. Middaugh say if he did get another chance to address us? If Ms. Lee says you should credit some piece of testimony from Mr. Aziz or Mr. Amiri, say, wait, wouldn't Mr. Middaugh point out all the other places that they lied? If Ms. Lee says that Ms. Rausch had no reason to mislead you, then say, well, wouldn't Mr. Middaugh point out that her sworn statement to the police used the phrase gun 3 times? If Ms. Lee says Mr. Myers had no legitimate reason to get out of his car, say to yourself, well, Mr. Middaugh would probably say that there's no legitimate reason to pull a handgun out of your pocket, manipulate it with your other hand, and tuck it back in while you're on the way to a store. And if Ms. Lee says that Mr. Myers should have waited to see what happened, say, well, Mr. Middaugh would probably get back up here and tell you how quickly men with guns could have turned that evening violent. I want to conclude by saying this. All of you responded to your jury summons, appeared, and have dedicated weeks of your life to this process. Jury duty is an awesome responsibility. We've asked all of you to come into court and decide these incredibly important issues because we have faith in your collective wisdom. The decision that you make in this case may not be the most important decision that you make in your life, but I guarantee you it is the most important decision in Mr. Myers' life. So I ask you this. Review all the evidence carefully. Read the judge's instructions thoroughly. Hold the state to its burden of proof faithfully. And return the only verdict supported by the evidence. Not guilty to both charges. Thank you.
Thank you, Mr. Middaugh. Ms. Lee, because the state has the burden of proof, Ms. Lee is entitled to a rebuttal argument.
Members of the jury, it is interesting to say that we should believe all of Mr. Myers' statements that he made on the stand in court, which was loaded with inconsistencies that I pointed out from his prior interview with the detectives. Yet, we should then go and distrust every single one of the major witnesses that we had testify in court. It's a very interesting argument to make. Ms. Rausch, if she were lying to help the state after watching the media or the news on this incident, why would she stop at just hearing one statement of it's a BB gun, it's not real? Why would she fabricate a very distinct fact of hearing a clink clink sound of a BB gun? It makes absolutely no sense in the light of the other testimony that you heard from her, where she didn't see quite a bit of what happened because Ali went off frame and she was in Big 5 in between the cash register and the gun counter. Her testimony made sense with where she was positioned during this incident. Saddam testified that his mind went blank after he saw Ali, his cousin, die right in front of him. It is reasonable to believe that he wouldn't recollect every specific detail that Mr. Middaugh asked of him on cross-examination. It's reasonable that there would be some issues with understanding the first interview where he did not have an interpreter when he spoke with law enforcement. Bilal testified to the events that led to them going to Renton rather than Covington. Why is it so hard to believe that 3 brown boys who are young and just learning how to drive got spooked by the police who were following them too closely? Why is that such a difficult concept to believe? To me, that makes perfect sense for 3 teenager boys who were trying to figure out which Big Five to go to, were going to Covington, and steered left and ended up in Renton because a cop was following them too closely. Now, Mr. Myers. Mr. Myers testified to a lot of things, but there are a lot of holes where we don't know what the truth really is, because the inconsistencies of how he testified in court and to what he stated to law enforcement on the night of the incident. To begin with, he testified when I cross-examined him that he was not surveilling the area. He told detectives on the night of the incident that he got off work and came to the parking lot because he likes to overwatch the area, which directly conflicts with his testimony. He stated during cross that he saw Bilal racking his gun and doing a press check with what he thought was a gun. And during his interview with detectives, he stated during 4 different times what he saw Bilal do, none of which mentioned racking the slide or press checking the gun. Mr. Myers claimed that Bilal stated things like, and I will censor these quotations, "I dropped the effing gun. There it is. I'm not getting on the effing ground." But during this interview with detectives, he stated that the only thing Bilal kept repeating was, "What the F, man? What are you doing?" Mr. Myers testified that Bilal and Ali raised their hands when they were told to during the incident. Here on the stand, he said that. And that Saddam was the only one who didn't. Well, during his interviews with detectives, he stated that 3 of them never raised their hands. He said, "I kept telling them to raise their hands and get down on the ground. They never listened to me." He mentioned in 2 additional instances during the interview with detectives that the boys never raised their hands. He initially testified during cross-examination that he did not point the gun at Bilal, and he kept it at low ready, or whichever language that he used to say that his gun was low, not pointing at Bilal. Yet, when we go frame by frame with the clear images of the gun pointed at Bilal, he then testified that he had pointed his gun at him. On multiple occasions, Mr. Myers testified inconsistently with what he had stated before. Now, defense stated during closing argument that Mr. Myers was concerned for the safety of his son, who was finishing up in Gracie Barra. Mr. Myers stated during his testimony that his son was due out the door any minute. And he also stated his son was on the other side of the glass putting his shoes on when this incident was occurring. For one, Mr. Myers shot Ali at 7:37 p.m. That timestamp is on the Big Five footage, and you've heard testimony to that effect. That is an odd time to expect your son to be walking out of a jiu-jitsu class. And we also saw surveillance video that we watched multiple times in court of the Gracie Barra gym. There is no child putting on shoes on the other side of the glass. Mr. Myers was arrested by Detective Pelzar, and you saw from the body-worn video footage that one of the first things that he asked Detective Pelzar is whether he can secure his truck. You see moments later, as he's with Officer Edmonds, he asks him whether his truck is okay, before even thinking to tell Officer Edmonds that his son is in Gracie Barra. This is not a man who is immediately concerned for the safety of his son when all of his actions and words tell us the opposite. What we do see from the footage are multiple people in the vicinity where Mr. Myers shot towards. Saddam is standing behind the column in front of the silver SUV that defense mentioned quite frequently. We know somebody was in the SUV at the time of the incident because minutes later we see on the Gracie Barra footage that they eventually drive away. There is a man standing right in the doorway of Gracie Barra behind Ali. Not to mention Mr. Myers' own son that he was so concerned about was inside of Gracie Barra. He was worried about his son walking out the door at that time. It would make no sense for him to fire 10 rounds in that direction. We heard testimony and saw photos of the bullet projectile that was found 100 feet away from the shooting location at Sierra Fish and Pets. You heard Wei-Han Wang testify that he heard what sounded like gravel hitting his car during the incident. And his car was right by Sierra Fish and Pets, 100 feet away from the shooting location. Now, defense argued that Mr. Myers was justified in shooting Ali because he had his hand down at his waistband reaching for his gun. Yet, we see a completely different response just moments later, when Mr. Myers is faced with an actual gun pointed at him by Deputy Lemus, who is not wearing his vest. There's the photograph of Deputy Lemus wearing his police vest. He was not wearing his vest during the time of the incident. He was plain clothes. Mr. Myers responded on cross-examination that he didn't know what the situation was. He didn't know that it was a police officer at the time, but that there was a man pointing a gun at him. He thought that it was a soccer dad, though he told detectives that he thought it was a dad from Gracie Barra on the night of the incident. Mr. Myers gave Deputy Lemus the benefit of the doubt, despite not knowing he was a police officer. He gave a man pointing a gun at him the benefit of the doubt, but he could not give 3 boys that he assumed the worst of the time to explain themselves, the opportunity to clear up what was going on before he escalated the situation every step of the way. Now, to argue and compare what Deputy Lemus and Detective Pelzar did in response to Mr. Myers shooting a 17-year-old boy 10 times, to Mr. Myers pointing a gun at 3 boys walking into Big Five, I don't really know how to respond to that, because those 2 situations are very different. 2 law enforcement officers pointing a gun at somebody who had just shot someone. Comparing that to Mr. Myers pointing a gun at 3 boys walking into Big Five. Now, defense also talked a lot about Ali's arm positioning at the time that he turned around. And we talked about this during the initial part of my closing. There just wasn't enough time for him to go and grab the grip of his gun the way that Mr. Myers described that he did. What's reasonable to believe is that as he's turning, he's dropping his arms to run. Who runs with their hands up in the air? Who's going to run like that? You're naturally going to drop your right arm as you're turning to the left to turn around. And the gunshot to his elbow, it's reasonable to believe that that's what he was doing. The video footage shows his shoulder drop as he is turning, and his arm is just barely dropping as he gets shot. And then you see his arm right away clutch his abdomen as he's getting shot multiple times more. It was Mr. Myers who caused concern for the safety of others that day, when he senselessly fired 10 gunshots at Ali, killing him with 7 of those bullets. It was Mr. Myers who used more force than necessary when he pointed the gun at Bilal while physically assaulting him against the window and the ground. It is Mr. Myers who is guilty of murder in the 2nd degree and assault in the 2nd degree, both while armed with a firearm, and I ask you to return verdicts to that effect. Thank you.
Thank you, Ms. Lee.